41st convening of the Fair Employment and Housing Council. We're being called to order, and to get us started, DFEH Senior Fair Employment and Housing Council Chair Broadfear will perform the roll call.
Thank you, Chair Mendelbaum. Chair Mendelbaum.
Present.
Councilmember Brodsky.
Present.
Councilmember Iglesias.
Present.
Councilmember Sandoval.
Present.
Councilmember Scher.
Present.
And Director Kish.
Present.
So thank you all for attending our meeting. We're being webcast live, and the video of the meeting will also be available afterwards for use on the website of the DFEH and the YouTube channel. We also have closed captioning available for participants, which you can find at the bottom of the Zoom bar features on the CC, and you can also chat the administrator if you're having trouble locating that or utilizing it. For those members of the public, you'll notice that as of now, you are currently muted and your video is disabled, and that's to allow for a coherent remote meeting. However, there will be all the regular opportunities to provide public comment as we tackle the agenda. And you can do that in a number of different ways. You can email the council at fehcouncil@dfeh.ca.gov, and we'll be checking that account throughout the day. You can also use the chat feature in Zoom, and the meeting administrator can read your comments aloud. You can also, if you prefer to speak directly, you can utilize the raise hand function in Zoom, or *9 if you called in, and that will allow the administrator to know that you'd like to provide your comments directly and to unmute you and enable your video at the appropriate time. So I want to first acknowledge and thank Adam Romero, DFEH's Deputy Director of Executive Programs, and Kara Broadfear, Senior Fair Employment and Housing Council, for their help facilitating today, and as always. And in addition to them, I want to thank all of you for attending today's meeting, and we look forward to your participation throughout the day. Copies of the agenda and meeting materials are available on the council's page of the DFEH website, the same page that the live stream video is on. And today's agenda includes review and considering the proposed housing regulations, which contain various modifications made in response to the 45-day public comments received. We'll also consider a proposed request for public input regarding reasonable accommodations for associational disabilities, and we'll receive updates from our various rulemaking and hearing subcommittees. First order of business is approval of the minutes, which is attachment A to the meeting materials today. Highlights from our October 26th meeting included review and adoption of the text of the proposed harassment prevention training regulations, and updates from our various rulemaking and hearing subcommittees. Any members of the council have comments or edits regarding the minutes? Hearing none. Any public comment specifically related to the minutes?
There's no raised hands and no emails, nor chats.
Okay, anyone want to move for adoption of the minutes?
So moved.
Any seconds?
Second.
All right, we'll proceed with a roll call vote.
Chair Mendelbaum.
Aye.
Councilmember Brodsky.
Aye.
Councilmember Iglesias.
Aye.
Councilmember Sandoval.
Aye.
Councilmember Scher.
Aye.
All right, the minutes are adopted unanimously. Next order of business is council member reports. Anyone on the council have things they'd like to share? Councilmember Brodsky.
I just want to say that on October 28th, Brandon Butler from the department and I attended a meeting of the LA versus Hate Action Committee, which is a program established by the Los Angeles Commission on Human Relations. And it was very informative. A lot of the constituents, their constituent organizations, spokespeople presented, and it was segued very nicely, I think, from our council's hearing on hate violence. And I wanted to also just note that this week from November 30th through December 6th is it's called United Against Hate Week. And it is a program that has been created by the LA Commission on Human Relations, the LA versus Hate organization. It's got lots of different components, and I urge people, if they're interested in this, to check out their website, which is lavs-hate.org. And one of the things that was most interesting to me is that they've established a 211 number for people to be able to report incidents of hate violence, and have developed curriculum materials. Folks are developing curriculum materials. It's a really comprehensive program.
Councilmember Scher?
Yes. Folks will recall that we adopted in the last set of housing regs some significant regulations on restricting local government's ability to do what's so-called nuisance or crime-free housing ordinances that penalize people with criminal history backgrounds inappropriately and potentially in a way that's very adverse to protected classes. And I just wanted to flag for folks that the LA Times recently did a very large study of those ordinances, and they found 147 cities, mostly in ones with rising Black populations, and a huge adverse impact in their study on people of color. So I know advocates are looking at that and hoping that the regulations that we adopted will be a useful tool in addressing what is an even bigger problem than I think we suspected when we adopted the regulations. So I just want to know, Tim and I are keeping an eye on that, as are many other advocates in the community. And so it just is a continuing concern, and we will report back if we hear news about the effectiveness of the ordinance and of our regulations in beginning to stop the spread of these ordinances. If anybody's interested in the article, it was in the November 19th LA Times, and it's part of a continuing study they're doing on this issue. And
Thank you.
Thank you. Councilmember Sandoval?
No, I was just saying thank you,
Oh.
Councilmember.
Any other council member comments or reports? So for on my end, as those on the council know, my term concludes at the end of the month, and I'll be stepping down from service on the council, and just want to tell you all how much I've really cherished the opportunity to chair this council and to work with all of you. And it's fun to think back almost 8 years ago when I was first appointed, along with Councilmember Brodsky, to what was then a brand new body that the legislature had just created. And it's been a real pleasure to witness the council become, in my view, a very deliberative, thoughtful, and fair-minded rulemaking body. And I'm also really excited about the council's recent efforts and furtherance of its other statutory mandates, such as holding hearings and requests for public input. And hopefully these recent efforts will lead to new regulations or recommendations to the governor or legislature about ways to improve the laws or policies within our civil rights purview. So thanks again for just being such great colleagues. I've said that all to you before privately, but I wanted to say that on the record, and both on the council and at the department. And to those in the public who have participated during the years I've been on the council, I want to extend my gratitude to you all for your insightful comments and participation. It certainly is makes our jobs a lot easier, and also it's critical to creating clear and workable regulations. So keep it up. That's my report.
Shia, this is Dara. We are going to miss you so much. Thank you for your incredible leadership. The effective and thoughtful way you chair the meetings, your contributions on the employment regulations and others, that you have been a real cornerstone of this council, and you are going to be sorely missed by everybody. But we wish you the best of luck.
And I
Thank you.
want to second that. I'm, yes, I do remember stepping into these shoes the same time, and I'm really going to miss you.
Likewise. Well, I'll be there. Like I told you, the first in-person meeting that we can all get together and kibitz over lunch. It's happening. So, but I really appreciate those comments.
And I just want to add mine too, and also just to praise you and thank you for your generosity. You've just been giving so much time and so much energy to this over the years. It's really wonderful, and I appreciate it.
Thanks.
Yeah, as a newest member to the council, I'd like to echo those sentiments. Thank you for your collegiality, your leadership. I really appreciate it as a newest member to the council. So thank you so much.
Thank you. All right. Well, I will turn it over to Director Kish to get an update on the greater department.
Thank you. I'm going to exercise my prerogative to say a few words about Chaya at the end of our program today. So I will save that for then. And in terms of the departmental update, I just wanted to let folks know that we're preparing to implement the new legislation that goes into effect on January 1st, 2021. And this year that includes the expansion of the California Family Rights Act. So there is educational material on our website as we speak today about the changes. And then starting on January 1st, the required posters and all the other materials that go along with the California Family Rights Act will be up on the website, and I encourage people to check that out. We're also very actively preparing to implement SB 973, which is the pay data collection bill. We'll be prepared on January 1st to accept complaints alleging violations of California's Equal Pay Act, and also preparing to launch the website or the portal through which large employers will be able to submit their pay reports by the March 31st deadline. So we do have FAQs up on our website. Those FAQs are, we're adding to those as we go along, and the next set, I believe, should be up hopefully by the end of next week. And finally, I just want to remind employers out there that this month is the last month to train employees on sexual harassment prevention training before the new year. Our free online trainings are up. I understand that last month, somewhere between 40 and 50,000 people took those trainings in California. I expect we might see a little bit of a jump this month, but a reminder that now is the time. That's what I have for today. Thank you.
Thanks, Director Kish. One quick question on the filings under the Equal Pay Act. How is that going to work in terms of coordinating with the Labor Commissioner's Office? Is it going to be kind of cross-filing like the EEOC, or what are those logistics look like?
Yeah, we already have a policy document that sets out certain information sharing and case sharing. Just because, of course, as you all know, the FEHA's prohibition of gender and race discrimination already encompasses many instances of paid disparities. So we'll be continuing that information and case kind of exchange, but we've been in regular meetings with them to figure out to what extent we want to formalize this now, or kind of take it as we go to see how many cases come in, what they allege, and which agency is best positioned to take one or another of the cases going forward.
Thanks. Our next item on the agenda is the consideration of the modified text of housing regulations regarding definitions, intentional discrimination, discriminatory advertisements, statements and notices, consideration of income, residential real estate practices, and disability. And that's attachment B to the meeting material. So you can reference the changes there, and I'll turn it over to Council Members Scher and Iglesias.
Good afternoon. The revisions you see in front of us are a result in front of you and that were distributed to the public are the result of our careful review of a number of comments we got in response to the first draft of the regulations on the items of intentional discrimination, discriminatory notices, statements, and advertisements, consideration of income, including Section 8, residential real estate practices, and disability, primarily reasonable modifications. We took a look at those, went back, made a number of changes in the regulations. Procedurally, where we are is this is the opportunity for the council to ask us questions about them, to determine whether they want to send them back out for another 15-day comment period or make any changes before they send them back out for a 15-day comment period. So Councilmember Iglesias and I will walk through the various sections. We'll take turns walking through the changes that have been made, some of which are minor and technical, and a few of which are a little more substantial, and some of which are additions. So I think the definitional sections are yours, I think.
Sure.
Okay.
All right, so thank you. So good afternoon, everyone. And again, I want to echo Councilmember Scher's gratitude for the comments. We received a lot of really good and helpful comments. So beginning with Section 12005 definitions, we revised the definition of adverse action, which is subsection B, just to make it more complete, to add in some typical types of adverse actions that we hadn't had in before. And then on page 2, on 12005B, B1B, capital B, we added a list of specific adverse actions that could be taken in the context of governmental housing programs. And we did this as part of implementing SB 329 and the article on source of income. One of the things we found was there's very clear legislative history that makes it clear that the legislature, when it adopted or enacted SB 329, had in mind clearly that housing providers would need to do a bunch of extra things, possibly to participate in housing programs. So we made those explicit. Then moving on to page 4, the definition of housing accommodation. We just clarified that the beginning of that to make it clear that housing accommodation and dwelling are synonymous. Just so it's just a little clarification. Then on the next page, page 5, we slightly revised the reference to any building, structure, or portion thereof in order to clarify, and this part is required by AB 1497, which is defining that people who use housing platforms are subject to the Fair Housing Act. So we made a change there, both in the definition of housing accommodations, but we also had to make a similar change in the definition of owner of housing. Then on the same page, letter T, military and veteran status, we included a number of changes to make that definition more accurate and more complete. Then let's see what else. So that's it for definitions. And then moving on to Article 3, intentional discrimination, that begins on page 10 of the handout or the attachment. So generally speaking, all these regulations are geared towards implementing the section 129558A of the of FEHA. And so in the definition section 12040, we added a definition of facially discriminatory policy, or sometimes called express classification. We added a definition because we needed, for clarity purposes, because we need to distinguish that particular type of violation from other possible violations. Then in the section below on 12042, burdens of proof and types of evidence, in response to a comment with regard to the types of evidence that might be brought to try to prove an intentional discrimination claim, we revised subsection B there, basically to conform to US Supreme Court precedent in the case Desert Palace versus Costa. Because the idea is that there's some cases that involve just direct evidence, and some cases that involve just indirect evidence, and some cases that involve both direct and indirect evidence. So we need to clarify that. Then on the next page, page 11, under subsection C, direct evidence, we revised the definition of, or we distinguished between two types of violation. Section C2, direct evidence includes an express condition stated orally in writing that conditions a housing opportunity on a protected basis. And we distinguish that from the idea of a facially discriminatory policy. The reason being there are two different types of violations, and for the one, the express condition, there really is no affirmative defense, but there is a affirmative defense for a facially discriminatory policy. So in response to a comment, we have added that very limited affirmative defense for facially discriminatory policies, which is taken both from some case law and kind of modified to conform to FEHA. So we made that change. Then on that same page, subsection E, we added a provision that notes that a facially discriminatory policy or express statement will also be a violation of section 12955C, and this is to be consistent with case law. And then below that, under subsection F, we tried to make really clear the distinction between the definition of indirect evidence from direct evidence. So we revised that. Then on the next page, page 12, we deleted former subsection E because it unnecessarily repeated section 12041B. And then the next section would be Article 6, discriminatory notices, statements, and advertisements. And again, this is to implement FEHA's section 12955C. So a small change that we made globally in this whole section was to substitute the phrase housing accommodations for the word dwelling, just to make it clear in terms of just for flow and kind of, yeah, for clarity really. So we changed that throughout. And then if you go to the next page, starting on page 13, in response to a comment, there's a statutory, there are a couple of statutory exceptions to liability under a discriminatory statement, and our first draft was a little bit more clumsy in terms of stating every protected class for each subsection that was not an exception. And so now, in response to a comment, we've tried to make it clear and a little bit more efficient what the statutory exceptions are without having to repeat all of the protected classes in each of the subsections. So that applies to a number of the sections in that part. And then if you go to page 14, at the top of the page, subsection A, capital A, we added an exception to when the phrase "no children permitted" would be unlawful, and we did that to conform to the exception, to the statutory exception that's stated in the exception there. And in the subsection just below that, B, we added an additional example of a type of ad or ad language that could violate the act for working professionals in response to a comment, to sort of fill out the group of non-exhaustive examples of types of phrases that can violate the act. And then on the next page, page 15, under section 12051 exceptions, we made a couple of changes. Subsection A, we deleted a phrase because the prior statement was too narrow of a limitation under the law. And then under subsection D, we added some language in response to a comment to clarify the meaning and scope of this exception. And then moving on next to the next article, the consideration of income, which begins on page 18. We revised this quite a bit. So subsection A, lawful verifiable income, in response to a comment, we have defined lawful verifiable income. So we've added a definition there. And then with regard to the examples of income, of possible lawful verifiable income, we added a couple and we reorganized it to be more user-friendly into groups. And then we, in some cases, in response to a comment, for example, we clarified certain ones. For example, veterans benefits in subsection B3, we tried to clarify what that was. And then let's see, next on the next page, page 19, subsection 6, which is in the top third of the page, we added that with regard to housing subsidies, housing vouchers, and rental assistance from nonprofits and charitable organizations in response to a comment. That really kind of fits as an analogy to governmental housing programs. So we added that one in response to a comment. And then in source of, in subsection C3 below, we deleted reference to rent guarantors and co-signers in response to a comment. And then in the next section, source of income, discrimination, and rental housing, towards the bottom of that same page 19, we added a number of specific examples of the types of actions that could be adverse actions under a source of income discrimination, basically to kind of make it more clear and coherent for this particular article. And then on the next page, page 20, subsection B in the sort of the bottom third of the page, in response to a comment similar to the before, we revised the exception because the prior limitation had been too narrow on the law. And then finally, in my part, with regard to aggregate income, the next section on page, or rather, excuse me, we didn't change anything on aggregate income, but on my last one, on the next page, page 21, financial income and income standards, where there's a governmental rent subsidy, we, in response to a comment, we deleted the last sentence of that phrase or that subsection. It's a really complicated issue, and the prior language just wasn't really clear in terms of what is allowed and isn't allowed. So for now, we have just deleted the prior sentence. Okay, so I'll turn it back over to Dara.
Thank you, Councilmember Iglesias. Article 14, residential real estate practices and transitions, similar to the harassment section earlier. The only change we made was to update some statutory references at the bottom to make them more accurate and more complete. The place where we made more substantial changes was on Article 18, reasonable accommodations and reasonable modifications, starting on page 22, in response to comments we got from a number of places. One of the places where we changed things throughout was we realized in response to a comment that how reasonable modifications are treated is different in a private market than it is in a property that has a federal government subsidy. Because in the private market, reasonable modifications have to be paid for by the tenant and or the homeowner in the case of condominium association, but in government subsidized housing, the owner or the management company has a responsibility to pay for those modifications, or many such programs. And those had kind of gotten blurred together in the discussion. And also blurred together in that discussion was the fact that the reasonable accommodation defenses, such as undue burden and fundamental alteration, don't necessarily apply in the same way in the subsidized context as they do in the private market context. So we have now separated out those provisions in an attempt to make it a much clearer discussion. So the first place you'll see that is in 12176 on page 22, subsection C. I think we changed, oh, that was from before. In subsection D on page 23, we deleted the language about reasonable accommodations or defenses of fundamental alteration or financial administrative burden, because we've separated that out for where it belongs, where there is no government subsidy, and have then taken it out of the sections where it is inapplicable to a government subsidized program who has the obligation to pay for it, or it's at least handled differently. On page 23, subsection F, we made some modification to the language regarding the timing of reasonable modifications and reasonable accommodations to make them more similar, because we realize that there are in fact occasional examples where at least one hypothetical had been proposed to us where a modification could have been made after judgment, for example, where there's an appeal and there may be a very long time period, and adding a grab bar might make sense if you've got an appeal that's going on for 2 years. So we modified this language to make it both clear and applicable to both reasonable accommodations and reasonable modifications. But I do note that on the top of page 24, on the very top line, I believe we have a slight typo there. I think judgment should not have an E in it. So we should delete that as we move forward. On page 25, subsection 3, again, we took out some of the language about reasonable accommodation, defenses, and interactive process because they're not necessarily applicable to all kinds of modifications, and because they were a little bit duplicative. And we also just clarified some language about withdrawing as opposed to denying an eviction to make it more accurate to what happens when a landlord withdraws an eviction. We then added an additional example on the bottom of page 25 and page 26. This is the one I was referencing, where there could be a circumstance, as was pointed out to us in some of the comments, where a modification might be appropriate post-judgment. We understand that that is not necessarily true, but it could be true in some examples, so we didn't want to exclude it. On page 27, in subsection C, we just took out in many cases because that was actually not an accurate statement. the individual always has the most accurate knowledge, and therefore the preference should be given significant weight. That also makes sure that we are providing a standard that meets or exceeds the federal standards as required by other portions of FEHA. The next change is on page 29. We had unintentionally omitted the word modification from subsection E near the top of the page, so we fixed that. And turning to page 30 is where we began to really try and distinguish between modifications in subsidized housing and modifications in non-subsidized housing. So subsection A, we deleted 2 of the defenses and moved them where they belong, but it is clear that a modification may be denied in any kind of housing for 1 and 2. So we took out 3 and 4. And then in B, we added them back in, which is generally true. And it's a little bit clearer where it applies, because there are some circumstances where it doesn't, as we will see later on in the regulations. And then in C2, on page 31, we clarified that the standard for whether modification is reasonable is very similar to the fundamental, is similar to a reasonable accommodation defense. It's reasonable if it doesn't involve a fundamental alteration, or if it is not an undue burden, financial administrative burden on the person paying for the modifications. We also clarified on the next page, under D, we provided some additional clarifications about when a modification would pose an undue financial administrative burden, just to clarify the language better and make it clear that it doesn't apply in subsidized housing. And again, we made that same clarifying language under subsection 5 on page 33. We also modified, and basically that language now says the entity being asked to pay for the modification, because in some cases that you know, if the government entity is involved, it doesn't apply. On page 33, we received a comment about the legal obligations of an owner to maintain or repair accessible features or maintain and repair the property. So we have added some clarity that if there is an existing obligation under state law, which there is in a number of circumstances, to maintain for example, an elevator or railing as part of just general habitability, or as part of particular building codes, or as part of habitable housing obligations, then the defenses of fundamental alteration and undue financial and administrative burden do not apply. Because if you're already obligated to do it under law, it's clearly not a fundamental alteration, and it doesn't seem reasonable to apply a financial administrative burden for something you're obligated to do anyway. So we made that clearer, and then we provided a number of additional examples of reasonable modification situations, which it seemed to us from our further clarification of this section and from the comments would be helpful. And we tried to break it down into different situations that could arise. Subsection 6I, 6 Roman numeral 1, is an example of like a broken handrail is an example of something that an owner would normally be required to maintain as part of various building and habitability codes. And therefore, the owner is clearly responsible for paying for that modification. similarly, in subsection II, or Roman numeral 2, the person with a disability lives in a non-elevator multifamily building, and that building was built at a time when it would have been covered by various obligations under federal law to meet certain structural requirements. And the owner in this case failed to meet those federal requirements. And again, we determined that therefore there is no fundamental alteration and there's no financial and administrative burden defense, because these were things that were supposed to have happened in the first place, and the owner is requesting the modifications to bring it in compliance with existing law. So in those situations, the owner again is responsible for making those modifications. In subsection Roman numeral 3, this is a situation where the tenant who uses a wheelchair needs some construction requirements, but those are not existing code violations. They are not things that were required by the architectural standards in place at the time that the property was built. So we've made it specific that at that point, the tenant would be responsible for paying for the modifications, and the owner would have a reasonable undue burden, would have a fundamental alteration defense possibly, but they have to engage in the interactive process. And in that situation, the tenant would be responsible for paying for the modifications. Moving down on page 34, we attempted to make more specific that there are sometimes situations where a request is not clearly either a reasonable accommodation or reasonable modification. It could potentially be either or both. And we've also made it clear that someone doesn't specifically have to use the correct words. If they're asking for some sort of change, then they don't have to guess whether it's an accommodation or modification. The owner has to consider it under both standards. And we've given some examples. These again would ensure that our regulations would meet or exceed current federal standards. And so, for example, we gave an example about carpeting, which is one of those that is sometimes considered a modification and sometimes considered an accommodation. If you have a hardwood floor or linoleum under the carpet, it's usually an accommodation to pull up the carpet. It's not really modifying the structure. The owner may change the carpeting out periodically anyway. If you have carpeting that doesn't have a subfloor and you need to pull out the carpeting for a wheelchair and install a floor, that's a change to the fixture of the actual structure, and that's a reasonable modification. So we wanted to make that more specific in several examples. We've actually used 3 examples here. And so in the first one, where there's a finished floor and removing the carpeting is simple, then that's an accommodation, should be granted, assuming it's otherwise reasonable. In a federally subsidized housing program, that would need to be done by the owner because they have an obligation under their contract and receipt of subsidies to pay for those modifications. And in B3 on page 35, we've provided some additional language and examples about carpeting. And we've done this in part because there is some existing guidance under federal law that we wanted to make sure we met or exceeded under the FEHA requirements. And also because these are very common issues that come up for tenants who use wheelchairs. On page 35, in subsection C of 12180, we just added some additional language, making it more explicit that certain expenses owners are obligated to pay for certain expenses as part of providing a reasonable accommodation or reasonable modification as long as they're not an undue financial administrative burden. So we gave some examples there. Then in page 38, we again tried to provide some clarity about when reasonable accommodation defenses click in and don't click in. And subsection 7 by striking some language that was confusing. On page 40, in subsection D that starts on page 39, this is the section that talks about the intersection between the rights of homeowners and common interest developments and the Homeowners Association and the homeowners, the Davis-Sterling Act and other laws that regulate condominium associations, and the intersection between that and the Fair Housing Act. And so we clarified in subsection 3 some of the language to make it clear which portions of the Davis-Sterling Act actually do continue to apply and which are superseded by the Fair Housing Act. Both FEHA and the Davis-Sterling Act make it clear that other laws can take precedent over the requirements here. And so we've just tried to make it more specific that if a condominium owner has some rights to make certain modifications just automatically, as long as they are consistent with all of the reasonable accommodation and other requirements of FEHA. And we've also made it more explicit that if any of their governing documents or other procedural requirements conflict with FEHA, that FEHA is the standard that has to be applied when looking at reasonable modifications. We've tried to make that more explicit. And then on page 40, subsection H is where we talk about housing owners which are part of a subsidized housing program and have their own obligations to pay for modifications. And we give two examples of those. The first one where there is a subsidy and the owner is responsible, and the second one where there is not a subsidy and the tenant is responsible for paying for the cost of modifications. And then we added some sections, both because there was some confusion and because there was some good case law and guidance from federal regulations that we had to meet and exceed. So we've added some additional examples starting in I. And these relate to when the modifications have to be restored, because the statutes are quite explicit that restoration is not required for modifications in common areas, and it's not necessarily required for modifications in individual units if it doesn't interfere with the use and enjoyment of future tenants. And it also makes it clear under what circumstances the tenant is responsible for maintaining the modified features and when the owner is responsible for maintaining the modified features. So for example, in Roman numeral 1, subparagraph 1 on page 41, the tenant installs a ramp in the lobby of a multifamily building and he pays for it because it's a modification. But the ramp's used by other tenants and other people and is normally in an area where the owner would maintain the property. So it is the owner's responsibility to maintain the feature. The second example in subparagraph 2 is the lease of a single family home. And because there is no, we gave two alternatives here where the tenant installs a ramp. If the tenant is generally responsible for shoveling the driveway, they have to shovel the ramp. But if the owner is generally responsible for shoveling the driveway, they have to pay for the shoveling of the ramp. So we just tried to be more specific about what circumstances maintenance of the features were included. And subsection K was added to make it clear that requiring someone to move instead of granting the modification is not permitted. I mean, you can offer someone a unit, but you can't make them move. We also dealt with the several situations in subsection L where the owner is willing to grant the modification but wants it to look different, wants it to have something fancier or something that fits more with the decor. And so we addressed that in L. If the modification is in, the owner can't insist on alternative modifications if the tenant otherwise meets the standards for reasonable modification. But if the owner wants it to be painted a different color, for example, or has a feature that doesn't cost the tenant anymore, then the tenant needs to comply with that request so long as it otherwise meets the tenant's requirements. And we gave 2 examples there on the top of page 42. One is that in that situation, the owner wants a design for a ramp for her apartment, and the owner otherwise meets the standard for reasonable modification, so she can install the ramp and pay for it, but the owner wants a more costly design for cosmetic reasons. This makes it clear that the tenant but that design doesn't meet her needs. It isn't perhaps ADA accessible, or for some reason it's not effective. So the owner has to approve the request without the alternatives. But in the second case, the owner gets a request to widen a doorway for someone who uses a wheelchair. And the doorways are normally trimmed with a decorative molding. And so in that case, the tenant should make the accommodations because it doesn't cost any more, substantially more, to meet both the owner's and the tenant's needs. And subsection M addresses a situation where the modification can be made to meet the tenant's needs, but the owner wants much more costly materials or decorations, in which case the owner has to pay the difference. So these are circumstances that arise often for tenants when they're negotiating a reasonable modification, and we thought it would be very helpful to provide more clarity and examples about where the obligations fall under different settings. We also added a subsection N involving owners, potential owners who are purchasing a house or a condominium that is under construction. Because California has some universal design laws that require owners to make certain kinds of features available to potential purchasers for accessibility. And we wanted to make clear the intersection of the tenants, the potential buyers' right to request those features and the owner's obligation to inform them of those features, and then how discussion and handling of those modifications would take place. Those are obligations that the potential purchaser has to pay for, but the owner has to allow them if they're otherwise a reasonable modification. So we tried to attempt to, with several examples on pages 42 and 43, address what, at least I know an issue that does come up for people with disabilities who are purchasing a newly built unit. This comes up in a number of settings. The last change we made was on page 44 in subsection 3, third to the last line. We added the word about restorations required for interior modifications only. That's directly from the language of FEHA, and there was some confusion about it by some of the commentators. So we decided to make it explicit. Those are the changes, and we went through a lot of them, so I don't know if people want to tackle it article by article and have a discussion, or if people have additional comments or questions. I defer to others about how the discussion should move forward from there.
Councilmember Brodsky.
First of all, I just want to compliment Tim and Dara on what an amazing, incredible amount of work this was. Everything is so complicated, and you've really and the examples are terrific. I think that's so helpful to people to see. The one comment I have is, and this partly reflects how complicated and how I really value the work that you did, but it's probably my ignorance, but I didn't realize until you explained that there's a difference between the responsibilities for when a property is subsidized versus when it's not. And I wonder if there should be just a piece of it at the very beginning of, I don't know whether it's 12.179 maybe, or 12.180, where you just spell out in a general way that distinction, because it would have helped me as I went through all of the text to understand kind of an overview of what I was going to be then looking at in much more detail. And there was one section that almost did that. I wrote down 12.180H.
That is the section that addresses subsidized units directly, yes.
Yeah, and that almost could, if that were moved up to the beginning, that would give, as I was going through it, that would have made it much easier for me to understand as I went through kind of why certain things why it would have given me that overview that I needed. It would have made it easier to understand the rest of it. But you guys did an amazing job.
Thank you. I'm certainly willing to try and do that. I don't quite know if I can do it on the fly. But maybe we can just add a sentence.
May I offer a recommendation? And just to remind everybody watching, where we are is that the council will decide whether or not to move this text into a 15-day comment period today. And if the council votes to move it into a 15-day comment period, that will start the comment period that will allow folks an opportunity to comment and be part of the formal rulemaking package, after which the subcommittee members will take all the comments and consider them, and if warranted, propose a new draft. So my recommendation would be, as is typically the case, if there's some kind of fatal flaw in the regulations, that we don't move them forward. We take them back and come in another meeting. If there are small changes, grammatical mistakes that we can make on the fly, we make them now before voting into rulemaking. And if there are substantive or structural suggestions, like the ones that Councilmember Brodsky just raised, I would take those and consider them during the 15-day period, rather than trying to make changes on the fly during the meeting. That's my recommendation.
Thanks, Kev. Thanks.
Yeah, that's certainly what I had in mind. I don't see that as a fatal flaw. I just saw it as something that could help make those sections a little more comprehensible.
I think we can put some kind of, direction or distinction near the beginning of the modifications section somewhere and make it clearer.
Other council member feedback?
I have some feedback. Found a couple of typos. I just want to flag those for y'all. So on page 26, with the example with regard to Miguel, it says Miguel has a minor stroke. So looks like sustain should be eliminated.
And there's only been like 6 people proofing this, so thank you. It's amazing.
My pleasure. And then just in terms of other, I found another one. Just in terms on page 20, with regard to reference section 12141A4, I would replace their source to the individuals.
Can you give me that again?
Sure. Page 20, and it's part of section 12141A4. I would recommend replacing their, THEIR, with the individuals.
Okay, I'm at 12141, which subsection? Oh, I see. Got it. Got it.
And there are some places where you use the word person and other places where you use the word entity as it relates to alteration of services or operations. I'm just wondering whether you want to include person or entity, just for consistency. And then just and then on page 11, I would recommend, and it's under section 12041 C 1 and 2, whether you want to include housing accommodation opportunity for both 1 and 2. Right now it reads housing opportunity, so I just recommended you may want to put a housing accommodation opportunity.
Got it.
And then I concur with my colleague, Councilmember Brodsky, that maybe some intros also for the examples. They're great examples, but perhaps there's an intros you could put in terms of what you're trying to describe in each one. I don't know if that's something that would work in these regulations, but I thought it would be a nice signal for the reader, so that there's some slight indication as to why this particular example is different than another example. And then global change with regard to whether you want to include an Oxford comma or not.
I will defer to my editors on that, but yes, we will look at that.
Again, thanks for this amazing work on this front.
I'd like to just flag an area where we struggled some under intentional discrimination, to see if anybody has any thoughts about it. Many of us were uncomfortable with including defenses to a facially discriminatory policy, but the case law at the federal level certainly supports that there are some circumstances, and we could think of several examples where you would want a policy that might in fact make some distinctions. And so the question then becomes, and I am referencing page page 11, subsection D. And we believe that the exception should be very narrow for a facially discriminatory policy. There's a great diversity among the federal cases that address this. There isn't much California law on it. There is no defense in the FEHC statute. So we struggled to provide a very narrow set of defenses, and these criterion here are drawn from a composite of some of the federal case law on this, although I will note that none of those cases actually found that the policy was appropriate, or very few of them found actually that the policy could be justified, but they did address these kinds of factors. And, you know, this is one way to go. Another way to go would be importing some of the factors from disparate impact. We think these are pretty narrow, but I don't know if anyone has any input on that, either on the council or when we send this out for regulations in a 15-day regulation. And I don't know if Councilmember Iglesias wants to say more on that. This was a provision that we struggled with. We hadn't specifically addressed facially discriminatory policies before. It was brought to our attention in the comments. We do think we have to separate it out based on the case law. We do think we need to provide some defense, and we do think it needs to be a narrow defense. The question is this about as narrow as we can get? Or do people have other thoughts?
My only comment would be agree that it's a difficult area, and FEHA neither mentions it as a liability nor a defense. So FEHA is completely silent on this issue.
I don't have any specific anything specifically to contribute to that. They look pretty narrow, and they make sense to me, but I'd be curious to see what public comment comes back with. The one piece in here I thought you were going to mention, and I'm curious as to where the definition of motivating factor came from.
That came from case law.
Is that so? It's verbatim, because
Yeah.
I've never seen something say that using the word something to modify or to be the subject of what moves the will and induces action. So I was really curious about where that definition came from.
I believe it's verbatim from a case. I don't have the name of the case on the top of my tongue, but I think we may have cited that in the eyesore.
It leaves me wondering what the word something is. You know, it's such a generic.
My guess is it's meant to be expansive because it's something that a person perceives. It could be an action, it could be a word, it could be a statement. So it's, I think it's meant to be expansive in terms of something that could move somebody to act.
I'm just not sure that it gives as much guidance if there was something more substantive, but if that's what it is, that's what it is. But
I don't know. I mean, I'll look up the case, and then if you have a suggestion, I'm happy to hear a suggestion.
Would anything be better than something? The word anything?
I think it's the thing part of the word that's gnawing at me. Something, anything is slightly better, Dara.
I don't know if that,
I know.
have to go back and look at it.
Yeah.
We did look, this was a comment. We did feel that in order for clarity in this, that we needed to say a little bit more about what a motivating factor was. And there were not a lot of obvious, clear definitions out there. So
It comes up in the employment context, but anyway, you know, that's a.
Yeah.
What is it? Where
So
does it?
the case the case it came from is Caldwell versus Paramount Unified School
Okay.
District, which is an employment case.
Yeah.
1995, 41 Calap 4th. And then it's also used, that case is cited in McDonald versus Coldwell Banker, a Ninth Circuit case in 2008. So that's where the definition came from.
Councilmember Brodsky, is there a definition of that term in the employment regulations?
Well, I don't, not that I am aware of in the employment regs. Not that I can recall. Chaya, can you recall?
No, not off the top of my head. Yeah, we'd have to look at that.
I
But
don't
this,
think so.
And this is one of the areas where the employment law under FEHA and housing law under FEHA are different. So it's tricky.
I'd say this falls under the camp of like food for thought for next round of 15-day
Yeah.
comment.
Yeah.
We may end up being in the same place, but we will look at it some more. I mean, it's,
Yeah, and maybe it is, it jumped out at me.
I had a couple other comments, some of them structural or grammatical, and then a few more substantive. On page 22 at 17176B, there was a reference to at the expense of the person with a disability or their designee that was removed, but it isn't reflected as a deletion in response to the public comment. So we'll have to make sure that we capture that in the next round that goes up. It was the product of public comment, and it looked like the subcommittee agreed with the comment, but it's not reflected in the edits. And then on page 28 at 12178, this is where we added various subsections and rearranged some of the examples, but the last set, which was subsection H and is now subsection O on page 43, doesn't show the double strike through H, which I think will make it clearer. Well, I mean, it's accurate, obviously, and it also kind of helps clarify how that is not new text, it's just kind of rearranged, those examples.
okay, so tell me that again, page 40.
Yeah, it's on page 43. Those examples used to be subsection H, and now it's O, but we don't have the double strike through of the H, we just have the O.
Got it.
So it's similar in theme to the one on 22, where we're just not showing the double strike through for a deletion.
My apologies for not capturing the edits correctly.
No worries. And then a couple kind of questions or thoughts, and some of this came in public comments. On page 20, where we're talking about aggregate income, I did wonder if that was too broad. Just reading the statutory text of 12955N seems to require uniformity in standards for individuals that are married or living jointly but not married. This seems to suggest that it's an affirmative obligation for both camps that income be aggregated. Is that intentional?
Yeah, so I went back and looked at the legislative history of SB 1098, which is the statute that enacted and added that provision to the law. And that statute, the legislative history is pretty clear that it was fostered by a concern that people who wanted to be roommates together were being charged, or that their aggregate income was not being taken into account. And the legislature was concerned that it should be.
Got it. Two more. On page 22 in subsection 8, there's a reference to discriminatory impact. The rest of the examples have discriminatory effect. Was that intentional, or should that be changed to discriminatory effect, or vice versa for the other examples?
Page, please, and cite again.
Yeah, page 22, it's subsection 8.
Oh, we should make that consistent, yes.
I'm assuming we should change that to discriminatory effect, since all the other ones are effect, rather than switching all of the rest of them.
Yes, catching that.
And then final one, page 39. And this is, again, came from a comment. It seemed like a good idea to add clarity that while a landlord can insist on a particular contractor or builder, they can require the modification to be done by a licensed contractor where required by law.
We believe that whether the contractor needs to be licensed or not is part of determining whether it's reasonable or not. And we don't believe it's necessary to call it out. It's not always. It can be a complicated determination, whether you're having a handyman do it or you're doing it yourself, or a tenant may be perfectly able to do something but if a contractor came in and did it, they might need to be licensed. So I think we decided it provided more confusion than clarity. We could look at that again.
Okay, well, I'm satisfied that you guys have, declined that for thoughtful reasons. Just wanted to flag it since it wasn't clear to me on the outset. Those are all my comments.
It has to be done to building codes, so we've made that clear. So then, if it's the kind of repair that a building code would require a licensed person to do, like some kind of complicated electrical or plumbing thing, but otherwise homeowners or tenants sometimes do repairs themselves, and that may be perfectly adequate if that's not inconsistent with the building code. So yes, thank you. I think we're comfortable leaving it there, but anyway.
Question about that is, does that implicate liability issues about who's liable if somebody's injured while doing the work?
Well, the work has to be done in a competent manner, and it has to be done to code. We haven't looked at liability specifically. Certainly the owner, in order to protect themselves from liability, can ensure that it is done competently and to code. And we feel like that's the legal standard. So I don't quite know what the implications for that are for liability.
Yeah, I was thinking if somebody's injured, who's liable? Does that go into the licensed contractor piece of it? I don't know.
I think it's kind of beyond the scope of this. The statute that it has to be competent and to code, I think gives everybody as much protection as you can. We can look at it again.
Councilmember Sandoval.
One more comment on page 41, where Councilmember Schur was talking about that an individual owner cannot insist that a tenant move to a different unit. Do you have any aversion to using the word require? And the reason being is because if the owner recommends, but he cannot or she cannot require.
I'm fine with that word. I don't see a problem with that word.
Okay, thank you.
Any other council comments before we turn it over to public comment? All right, seeing none, we'll turn it over to public comment on the draft.
We have one raised hand from Whitney Prout, who I will now unmute.
Hi, good afternoon. As always, first, I'd just like to thank the subcommittee. Oh, I'm sorry, Whitney Prout on behalf of the California Apartment Association. I'd like to thank the subcommittee, as always, for all of their work on this. We don't always see eye to eye, but I certainly appreciate the enormous amount of time that I know goes into reviewing all the comments and making those edits. So thank you generally for that. I'd also like to thank you more specifically for some of the clarifications that were made that my organization and several others requested, in particular as it relates to the source of income provisions. We do still have some concerns, both that we addressed in our comment letter and also a couple of things I've flagged based on the revisions that were made. I've only done a preliminary review at this point, so I won't go into any of those specifically right now, but will, of course, I'm assuming the council votes this into another comment period, submit an updated comment letter. So I just wanted to check in and say thank you. And if I can, I also just wanted to take the opportunity to reflect the comments of the other council members to you, Council or Chair Mandelbaum, just to thank you for all of your service to the council over the years. I've appreciated working with you, and you will absolutely be missed.
Well, thank you, Whitney. I really appreciate that, and you're certainly top of mind when I was talking about people whose input we really value, and so thanks for continuing to contribute that.
Yes, I would say that as well. We always appreciate your thoughtful comments on behalf of your clients, and we look forward to getting them on this draft as well.
There are no additionally raised hands, no chats, no emails.
Okay, well, I have been trying to jot down a list of what I think are the on-the-fly changes that we would be making or considering when voting on moving this forward. So unless anyone wants to has a similar list and wants to take the lead, I can endeavor to itemize them, and anyone can correct me if I'm missing any. Okay, so what I have is on page 11, we're going to change. Well, so this was the one I wasn't sure. We had Councilmember Sandoval had suggested inserting the word accommodation in between housing opportunity. Was that?
That one, so thank you very much, Councilmember Sandoval. The housing accommodation refers to the physical structure, and housing opportunity refers to the concept of the possibility of a person getting housing. So in that context, housing opportunity would be the right term, and housing accommodation would not be appropriate. Do you agree with that, Councilmember Scher?
Okay, so we'll leave that one off. So moving along to, then my first one is page 20. We're going to change the word there to an individuals.
Correct.
Yes.
On page 22, we're going to.
Oh, sorry. That should
yeah.
represent any individual based upon the individuals.
Sorry, the individuals rather than an individuals. Thanks.
Right.
Page 22, we're going to put back in and then reflect in double strike through the at the expense of the person with a disability or their designee at 12176B. And we're also going in subsection 8 to change the term discriminatory impact to discriminatory effect.
Yes.
On page 24, we're going to correct the spelling of the word judgment.
Yes.
On page 26, we're going to remove the word sustains.
Yes.
And then on page 41, we are going to have the word require instead of insist.
Yes.
And that is the list I have for
I think there was a
on
number.
the fly.
I think there was a numbering one as well on page 43. Examples of reasonable modification. The subsection number should be shown as parenthetical H with a double strikeout.
Oh, yep. Thank
And
you. That was my
O
one. I
should
missed
be
it.
shown as a double underlined addition.
Right. So with those modifications in mind, or incorporating them rather, I'll make a motion to adopt the modified text and authorize the department to post for 15-day public comments. Is there a second?
Second.
All right, we'll do a roll call vote.
Chair Mandelbaum,
Aye.
Councilmember Brodsky,
Aye.
Councilmember Iglesias,
Aye.
Councilmember Sandoval,
Aye.
Councilmember Scher.
Aye. And I want to thank everybody from the public and from the council for their support and helpful comments on this.
I second that. Thank you.
Well, thanks for all the work you guys are doing. So we will move right along to our next agenda item, which is considering the request for public input regarding reasonable accommodations for associational disabilities under the FEHA, which is reflected in attachment C to the materials, and I'll turn it over to my colleague on the council, Councilmember Brodsky.
Yes, this is what we discussed this last meeting, and it has now taken root as a formal request for soliciting input on the issue of whether an employer has a duty to engage in an interactive process with and provide reasonable accommodation for an employee on account of the employee's association with a person who has a mental or physical disability. And what we've done is lay out summarize what the law is. The case law, which we talked about last time, is based on a case called Castro Ramirez, which incorporates dicta on this, interpreting the language of FEHA. And then the enclosure has a list of seven questions that we're asking for input on. And of course, the seventh question is, are there any other topics other than the ones that are specifically described in 1 through 6? So we really want to get input. This input is due back by no later than February 1st. And when we get responses, then we'll bring it back to the council and synthesize what we've learned and get back to you. But this is a preliminary step to considering whether it is appropriate for the council to enact regulation on this or not. No decision has been made one way or the other. It really is a solicitation for input. So look forward to hearing from members of the public as well as council members on this and by February 1st.
We really appreciate this query because I think this has implications on the housing side as well. So we hope we get broad input on this issue. And as at the end of the attachment here, you'll see where submissions can be emailed to fehcouncil@dfeh.ca.gov or mailed to Adam Romero, the Deputy Director. So we do look forward to receiving whatever we get.
Yeah, and I just really want to credit Councilmember Brodsky for highlighting this and encouraging the council to turn its attention to it over these years. You know, whether reasonable accommodations for associational disabilities required by FEHA is a real open question, and it's going to require a careful review of statutory text and the case law and all the public input we get. And that's really what our council was built to handle when it comes to our statute. And I think the request for public input document does a good job of laying out the state of the legal landscape, both specifically in this context and in the analogous context of perceptions of disability. And there is some case law on how to interpret the statutory text of FEHA for perceptions of disability. And then I think the request for input also recognizes that this may extend beyond merely a straightforward statutory interpretation and begs additional policy questions. So we try to kind of prompt feedback on both of those prongs, and I'm very interested to see what we get back.
And of course, one of the impetuses for this is COVID. And so, you know, if we get the input, and then hopefully we can move expeditiously once we have, if it's appropriate to do so, and it may or may not be, but if it is, you know, that we can move expeditiously on this to help folks out there.
Do we know whether any individuals have filed complaints using this as a basis for the DFEH? Any anecdotal information or data that we have?
I don't have any information right now about any complaints that have been filed.
Well, we know certainly the federal court decision, you denying the motion to dismiss had FEHC claims. So certainly that would be one that went through either an investigative process or an immediate right to sue process.
I also agree that this is a very worthy thing to do and to elicit the public's input on it. I don't have any particular input myself. I thought the memo was very helpful in laying out the possibilities. The only question I had was whether or not there's been any attempt to see if there's any law review analysis of this. There may have, this strikes me as a perfect idea for a law review article that somebody maybe figured out and did, but that might be another kind of source to look to for some analysis and some thoughts.
I did a lot of legal research in the beginning, but I don't recall finding something directly on point, but I'll look back in my research and see whether there's something there. And if not, maybe I'll write the law review article.
There you go.
well, yeah, I was going to say, if only someone could, put all of that good work to double professional use by having academic publishing requirements, but I recognize yours might be more in the housing realm, Tim. In any event, any other council member comment before we turn it over for public comment? All right. Any public comment on attachment C?
There are no raised hands, and a reminder to the public to raise your hand in the chat or in the menu bar at the bottom if you'd like to speak. No chats and no emails. No raised hands. Oh wait, there is a chat, excuse me.
Yeah.
Are you seeking legal input, or are you interested in employer input regarding this topic? And this is from Genevina Mayberry.
Yes and yes. Certainly, our regulations are guided by the statutory law, but we've also, asked for input on policy considerations, and so we would certainly value input from employers on the topic, even if it's not specifically tied to the statutory interpretation.
Absolutely.
All right, no further comments, raised hands, emails. Then we will solicit a motion to adopt the request for public input and authorize the department to disseminate it to the public.
So moved.
Any seconds?
Second.
All right, all those in favor, or no, we're going to do a roll call. That's right. Or remote processes.
Chair Mendelbaum,
Aye.
Councilmember Brodsky,
Aye.
Councilmember Iglesias,
Aye.
Councilmember Sandoval,
Aye.
Councilmember Scher.
Aye.
All right, the motion passes. Our next item is an update from the Criminal History and Employment Hearing Subcommittee, our first kind of debrief since the hearing itself, and I'll turn it over to my colleague on the subcommittee, Councilmember Sandoval.
Thank you, Chair Mandelbaum. So we had, as many folks know, a hearing that took place to address the Fair Chance Act, and we had a robust discussion all day. We had different individuals provide ways that they suggested there could be some changes with regard to the regulations or the law, and some other types of information that I think could inform the council moving forward. I know that our colleagues in the DFEH are putting together a memo or items that they are looking through the council, and I believe they will be providing some information to the council members in terms of some of the key points that were raised during the hearing. So I thought it was a great day. Chair Mandelbaum, do you have anything else to add?
No, I agree, and I think it's an area kind of primed for us to have some follow through after the hearing in terms of proposed policy or legal improvements or regulations. So, there'll be a section down the road on subcommittees, but I hope we kind of stay with this topic and produce some deliverables after that.
Great.
Can I just add, since our hearing, also I want to alert people that Legal Services for Prisoners with Children has been having webinars on giving advice on how to deal with ban the box type issues and criminal history. So if anybody's interested, you might want to check out their website, which is, well, it's Legal Services for Prisoners with Children. I'm not sure what the actual website is.
Great. Any other council member comments? Any public comment?
No public comment.
All right. Well, I'm going to punt it back to you, Councilmember Sandoval, because we're up to the update about the Criminal History and Work Opportunity Tax Credit Subcommittee.
Thank you, Chair Mandelbaum. We do have a draft that is something that I want to address and think more broadly whether or not this issue, because it deals with matters involving criminal history, whether this should be combined with the other subcommittee I serve on moving forward, and wanted to get direction from either Adam Romero or Kevin Kish about what do you think would be the best, or other council members, particularly since now one of our colleagues, Mr. Ortiz or Councilmember Ortiz is now Judge Ortiz, and he was serving as a colleague of mine on this particular subcommittee. So,
well, I think that's a good it's a good one to revisit in the subcommittee assignment section a little later in the agenda, and maybe this is the right time to add someone to that.
okay.
Any other council member comments? Any public comment?
No public comment.
All right, I'll turn it over to council members Brodsky and Schur rather to give us a update on 11135. And you're both muted, so perfect.
This is Councilmember Schur. The regulations are still under review from the agency. We hope to be able to move forward on them somewhat soon, but at the moment, that's the status.
All right, any council member comments? Public comment?
No public comments.
Our next update is from the Hate Violence Hearing Subcommittee, and I'll turn it over to our now lone subcommittee member, Councilmember Brodsky.
And I don't really have anything to report. What I expect that we will be reviewing what was presented at the subcommittee and then coming up with a game plan from there. But it's a work in progress.
Thank you. Any council member comments? Public comment?
This is, I do want to say it was a really impressive set of panelists, and I learned a lot, and it was a great hearing.
Agreed.
No public comment.
Okay, well, those last couple updates have been a nice little intro for our next agenda item, which is discussion of additional subcommittee assignments. And obviously there's a number of subcommittees that either I or council member, now Judge Ortiz, were on that need second members. That said, the council will hopefully also be getting some additional members over the coming months, and so they'll be able to take some of those slots. So I guess my thoughts would be assigning where there's imminent work or time-sensitive projects that need to be generated, and leaving some of the others for potential assignments for new council members. Do people have thoughts on kind of additional assignments that should be made at this meeting? Councilmember Sandoval, what's your thoughts on the work opportunity tax credit item? Is that something that would be good to add someone now, or is that something that can be held in abeyance pending new appointees?
you know, my thought is that it would be good to have somebody join. Again, I'm unclear when we'll get a new council member, but I think we can wait till the next meeting for that one. But I do have an interest in the hate violence hearing, so I'm not certain if Councilmember Brodsky would like my partnership in that one.
Love it. That would be wonderful. Because Judge Ortiz was the member who's no longer on there, and it would be great. That would be wonderful if you could join us. Go ahead.
Great. All right. Well, we've got one new assignment. Any other thoughts or modifications people want to make at this meeting? All right. Well, hearing none, any public comment on the critical decision of assigning Councilmember Sandoval to the Hate Violence Subcommittee?
Thanks for volunteering.
My pleasure.
No public comments.
All right. Well, I will move to make that assignment for Councilmember Sandoval. Any seconds?
Second.
All right. Roll call vote.
All right, Chair Mandelbaum,
Aye.
Councilmember Brodsky,
Aye. Can I vote twice?
Mhm.
Councilmember Iglesias,
Aye.
Councilmember Sandoval,
Aye.
Councilmember Scher.
Aye.
Well, that wraps up our list of agenda items. We, as always, have an opportunity for additional public comment if anyone wants to make any remarks that aren't specifically tied to a item that was on our agenda. Now's a good time to do that.
We did receive one email comment, and this regards the request for input on duty to accommodate associational disability. It's from Mark Murray, CTA. I wanted to comment about severe autoimmune diseases and how they relate to associational disabilities. I know that these diseases can be considered disabilities, and this issue is especially pertinent during the current pandemic. We have teacher members with spouses or significant others with these diseases. It is important that a person in this situation be treated in the same way as they would if they had the disability themselves, as they live with a person who could easily get sick if their partner catches something like COVID at work. If the teacher is able to be considered with an associational disability, then the school district would have to make accommodations for that person to work from home. Thanks, Mark Murray, CTA.
I think that's a great example of why this is a very topical issue, in addition to being a open legal question that's been around for a few years now.
And some districts are assuming that to be the case and engaging in the interactive process.
No additional public comments.
Great. Well, that wraps up today's agenda, and information about the council's next meeting will be posted in the coming weeks.
So I'm going to take my time now, if that's all right, and say a few words about Chaya. As we know, and this will be very short, just not more than 5 minutes, but I wanted to take a moment really to thank you. As everybody knows, this is Chaya's last meeting. He has been chair since the creation of the council in 2013. And in my view, his contributions to the council and also to the people of the state of California have been extraordinary. Chaya took his oath of office at the first council meeting in June 2013, along with former council members Shanae Franklin Minor, Patty Perez, and Andy Schneiderman, as well as Dale Brodsky, who will now be the only remaining council member from that original cohort. And this milestone has prompted me to take a step back and review the work of this body over the past 7.5 years and now 41 meetings. And that work has placed the council in many instances at the forefront of civil rights, not just in California, but in the nation. Chaya has supported that work through literally thousands of hours of volunteer service. I don't know if you bill this or put it into your time keeping records, but I know that it's a lot, both as a member of subcommittees that have created regulations and in his role as chair, which, as everyone has just finished observing, he shepherds and supports every single action of the council. In the first 2 years, in 2013, 14, and into 2015, the council's work involved major rulemaking packages to update and amend older regulations that were in place but needed to be revised, interpreting the Fair Employment and Housing Act and including the California Family Rights Act. In more recent years, this body has moved beyond what was already in place and has formulated new rules, including regulations governing the consideration of criminal history and employment decisions, which anticipated and influenced the California legislature's subsequent passage of the Fair Chance Act, enacting in statute many of the elements of this body's interpretation of the law. We've also promulgated regulations regarding transgender identity and expression, national origin discrimination, including workplace language restrictions, and discrimination in employment based on religious creed and age, all of which are among the most comprehensive articulations of these areas of civil rights anywhere in the country. And of course, as we observed today, we're in the process of considering the second round of fair housing regulations. The council's historic first round went into effect in January of this year, and for the first time interpret California's fair housing laws, originally enacted by the Rumford Fair Housing Act in 1963. And just in the past few months, we've exercised the council's authority to hold broader civil rights hearings, not specifically tied to a regulatory project, but instead intended to shine light on civil rights issues that impact our communities and our lives. And I don't feel any hesitation in saying that none of this would have been possible without Chaya and without his leadership. At the same time, I think we're well positioned to continue this work, this ambitious work going forward. I think one marker of a strong leader is being able to step away from a role with confidence that what you started will continue. And Chaya, I think you've modeled for us that kind of leadership, both in your administrative role as chair, but also in your approach to the substantive work. Unlike some other rulemaking entities that have a narrower focus, this body makes rules that apply in one way or another to every single person in this state. It is a massive undertaking, and no single one of us can know everything there is to know about every person's situation, every business, every agency, every local government. It's not possible. And Chaya, without fail, has sought the input of people who will be affected by the work. He's engaged respectfully with the stakeholders, and where facts and evidence warrant it, he's changed his mind. And he's demonstrated for us how to do that elegantly, all while remaining committed to our civil rights mission. On a personal note, from literally the first day I was appointed to my role, Chaya has been uniquely generous with his time and counsel to me. And you heard Councilmember Iglesias use the word generous earlier, and I also want to use that word. You are incredibly generous, not just in our work together on the council, but also in my role leading the broader department. And Chaya has been for me a teacher, a sounding board, a support system, and a mentor. We've experienced a lot of life events during this time, not just the pandemic of the past few months, but we both got married. Chaya became a father. And my one regret about our remote meetings, which are otherwise really great, allow us to get a lot done, is that I can't be with you in person to thank you and congratulate you, and to give you this plaque, which I have not unwrapped because I have to send it to you, but which reads, State of California Department of Fair Employment and Housing Service Award, presented to Chaya Mandelbaum, Chair, Fair Employment and Housing Council, in recognition of distinguished service, protecting and advancing the civil rights of the people of California, 2013 to 2020. Chaya, I'm looking forward to seeing you in person before too long and seeing everything you do in the future. Thank you a million times over for everything.
Thank you, Kevin. That was really, really humbling and eloquent. And thanks so much for those remarks and for that walk down memory lane, both in terms of what the council's accomplished and you and I first getting to work together. And it's been an experience I really treasure. And I'll certainly maintain all these friendships I've made and see you guys soon at the next meeting when we can, indulge the luxuries of actually getting to hang out in person. So thank you everyone for attending and participating, and happy holidays to everyone, and stay safe.
Thank you.